I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, I think we're doing our favorite episode of the year. It is our annual look back, look forward episode, where we not only look back at what happened in 2025, but we also look forward to what may start to happen in 2026. And to help with that, I have invited my co-chair of the privacy, cybersecurity, and data practice here at Hogan Lovells, Eduardo Ustaran, to the podcast. Many of you know Eduardo because you've heard him on many episodes in the past. So I'm so excited that he is returning to the podcast this morning for us to talk about what we have not only seen in 2025, but also to think about what predictions we have for 2026. So Eduardo, welcome to the podcast.
Excellent. Great to be here and to join you for yet another year of exciting developments. So let's crack on.
I mean, it's amazing, Eduardo, that I think this is our third version of this episode, which means that we've been at this for 3 years.
Yeah, and we need to come up with new things every year. So there you go.
Well, I think fortunately in our space, there is always a lot of new things. And so why don't we get right to it? 2025, I think we probably both would agree, was a really interesting year in the world of data from many different aspects, not only around traditional privacy, areas around how cybersecurity has developed, but also a continued focus and maybe more specific focus on technology, AI being at the top of that list, but not exclusive to AI. So from your perspective, maybe starting in the UK and EU, what have been the key themes you have seen in 2025?
So it is obvious that we need to start with AI and perhaps alongside AI innovation. And we are at the stage, the entire world is at the stage where we are transitioning to a new type of technology that is going to have potentially a great impact on everyone's lives. And of course, like all technologies, and all digital developments, they have a real impact on how information is used, personal data, the impact on our lives, on our day-to-day way of operating digitally. So that has attracted a massive level of attention from policymakers that are looking at how to make the law more effective, and of course from regulators that are also looking at how to make sure that existing laws are more effective. So that is going to continue. It's been the big topic. And on a positive note, I would like to say that I have also seen a very pro-innovation way of thinking, or particularly realistic way of thinking amongst regulators worldwide in relation to these issues. So there is room for hope in terms of how we address this going forward. Other issues that have been very big this year that we've seen regulators being very focused on are biometrics and anything to do with data that is extracted from our bodies and can be used to identify us. When that is mixed with vulnerable people, like children, for example, that becomes even a higher topic. And of course, geopolitics are everywhere. And the way in which different developments in terms of politics in any part of the world have affected privacy, data, cyber, and AI has been another point of reference that we have had to look into.
Yeah, I mean, it's really interesting, some of those themes, because we certainly have seen some of those same issues in the United States. And one of the things I know we want to get back to is that idea of maybe the changing focus and regulation to maybe be more pro-innovation and maybe rethinking how the European, UK policymakers have been approaching tech regulation, data regulation, and, perhaps repositioning their approach, which may carry us through into 2026.
Indeed. And certainly, both in the UK and the EU, the reform of existing laws in order to make them more pro-innovation, if you want, or to align them with the innovation drive that we're seeing at the moment has been very consistent. And it's interesting because, of course, the UK and the EU are no longer deciding at the same time about these issues, but we have seen parallel developments. Earlier this year, the UK passed the Data Use and Access Act, which is a law that reforms the UK GDPR and addresses some technical aspects of the law to try to make it a little bit more pragmatic, if you want. But much more recently, the EU, the European Commission, has published their Omnibus Act or the Omnibus Package, which essentially is a simplification proposal that they still have to go through all the legislative steps, and we can talk about that in the first part of next year. But essentially what the European Commission is seeking to do is very much what the UK has also done, which is to tweak, to change certain technical aspects of the GDPR, the Data Act, cybersecurity, and the whole digital framework in order to make it perhaps more realistic. And of course, this is proving controversial because the moment that you change laws and you align them with innovation, because of all these geopolitical factors that we have also encountered, that gets twisted in a way by people from all walks of life in a way, and seen as something that is potentially a threat to the protections that the law are meant to provide. So you can see that innovation leads to potential changes, leads to controversy, and that is very much the flavor of the year.
Yeah, 100% on that one. And I guess maybe the key question for you, Eduardo, is that, from as you see that focus change perhaps from individual rights, individual protections, areas where we're trying to, figure out how to place the individual at the top of priorities, which has been obviously an area of focus for EU and UK data protection law for a very long time. And now perhaps to see that shift in some ways to what the emphasis could look like for a pro-economic growth, pro areas where we're going to build out a tech sector in Europe or a tech sector in the UK and not just be, a consumer of other countries' tech sectors. That is a change in maybe values and change in the ways that we are at least taking kind of some of the ways that we are going to prioritize things and flip them. Interested in whether you think that that is overstated, or do you feel like that is where the public wants to go in the way that the policymakers are going to react?
Well, policymakers, understandably, are selling this as something that doesn't really change the nature of what the law is trying to achieve. So that protection for fundamental rights, as we understand them in Europe, the protection of the individual, is not meant to go away. And policymakers have been very careful to emphasize that. Of course, people, as you're saying, disagree. And activists are very much up in arms, saying we are selling our soul here and we are devaluing what we created and what Europe has been so good at over the years, which is to protect people's rights and to create a framework that is copied around the world. And now we are abandoning that. I personally think there is a lot of exaggeration in that way of thinking. I am a lawyer. I'm not an activist or a policy or government affairs representative. I look at what the law says today, and I look at what the legal reform is trying to address. And when you look at that, what you see is essentially changes, for sure, certain changes, but that are trying to reflect what is already happening in practice and is trying to, this reform, both in the UK and in the EU, is essentially following the thinking that both regulators and the courts are already adopting in this respect. So perhaps there is less room for controversy when you look at the detail of the law. But of course, if I am an activist, I'm going to say, well, we are still selling our soul here because ultimately we are weakening the system. And I think the real question is whether changes to the law weaken the system or indeed make it stronger because it's more realistic and therefore more effective. And the jury is out. The jury is definitely out, and this debate will continue.
And so, changing landscape, Eduardo, I think maybe one thing that has caught folks off guard is maybe how quickly maybe the sand seems to be shifted here. Because I think one of the things that the European Union and the UK have done quite well is being thought leaders in the way to approach digital regulation, primarily through personal data, but increasingly now moving in through other aspects of digital regulation. And to see those things start to come into force, and then to say, well, maybe we didn't get this quite right, and kind of go back and think about ways that we can try to re-envision it, is something that I think has been moved faster, perhaps, than many people expected and predicted. And that could be part of the geopolitics, as you're mentioning. It could just be the way that the world is shaping, especially as folks fear like how countries are going to be leaders in the GDPR. But if I'm looking at the gap between the time where we thought maybe we want to imagine what the directive looked like to the time where we have the GDPR, from the time where we have the GDPR, around 2018 to where we are, hey, maybe we should come back and think about how to tweak the GDPR. It seems like we are trying to be more reactionary, perhaps, around where things are moving than we are trying to say, let's let a long period of time go by, gather evidence, try to figure out whether we're getting the right balance.
You need to then pay attention to what is really happening rather than what is being said. Because if you look at the law as it is today in Europe, the GDPR and the wider data protection framework, essentially, you've got a law that has been evolving over the years, since literally the 90s, before the internet. And we are now in the era of AI. And in the same way, the technology has evolved a lot from the 90s to today. The law needs to evolve. And one of the wonderful things about the area of law in which we all practice, and our entire global team practices, is the fact that this is a law that needs to be adapting to technology in order to be effective. So this is what is really happening. And when you look at the changes that, again, have come into effect in the UK and are being proposed in the EU, the principles of the law are not affected. The rights for individuals are not really affected. The fact that in terms of how you comply with the right of access, you can call out those who are being vexatious and taking advantage of the system, is something that regulators tolerate anyway today. So that's not a real change to the rights. And the obligations around accountability of organizations and the requirements around data protection, impact assessments, and data breach notification, and everything else that goes into the requirements for controllers of personal data, that is not changing in any meaningful or profound way. So it is not a revolution. It is not the UK or the EU are abandoning their principles. I think it is an evolution in order to adapt the law to technology. And that is still compatible with thought leadership. Speaking of which, I think the US itself has had a different evolution, again, over the years. And the US had, for example, a very firm approach to enforcement of the law, and on a state-by-state basis, that you have adopted a number of laws dealing with very topical issues. So what we also wonder is what is actually happening, or what has happened in the US in 2025, and how has the US adapted to these technological changes, taking into account also the political changes that have taken place.
Yeah, it's a really good question, Eduardo. I would say maybe 5 big themes that I have seen in 2025 here in the United States. First is the way that we are focused on artificial intelligence, right? Same way that you're describing the implications and how things are focused on in the UK and the EU, that debate is happening here in the United States. And it should be looked at in the context of the change of administrations. Obviously, we had an election here and, a change in the administration where Donald Trump was elected and had a very different perspective on approaching regulation generally, and then in particular with the way that we're approaching technology regulation. And thus the federal government's point of view on this has changed very much of trying to be pro adoption of artificial intelligence and maybe, in their views, taking out some of the constraints that the Biden administration had put into place around using and evaluating, especially kind of bias oriented concerns, but also replacing those bias oriented concerns with its own views about ways that political bias may be factored into the way that AI technologies are being run. And then linked AI to an energy debate, which obviously is something that is really important and often overlooked in the way that AI relies on data centers and data centers rely on large amounts of energy. And energy debates and energy policy has long been an issue here in the United States. And so this is a kind of a unique way that we're getting back into that particular debate. But I think there's very much of a focus of like, well, this may be what the federal government is looking at. How is it that we can create a resilient, sustainable approach to managing AI oriented issues such that once we know that the politics change and the policy changes, that we can not be just reactive, but we can actually be thinking forward about how to approach that. And I think that has been very much of a trend in 2025. And in some ways, I think really important in that you think about the way that the internet was here and created in the United States, and the way that we were thinking about the regulation was largely a deregulated environment. There was not really any type of broad scale approaches to managing issues that came out online. And in some ways that fostered a really wonderful, innovative culture. Obviously, for many of the reasons that we work on a day-to-day basis, also had a number of harms. And I think that balance now is starting to shake itself out about, well, what does the future of AI look like? And are we in a position where we want to approach AI regulation in the same way that we approached internet regulation, largely just the deregulated environment, let industry sort it out? Or is it that we want regulatory approaches, policy oriented approaches, legal laws to be able to guide how that mix is going to work out? And you're not really seeing that so much at the federal level right now with the change administrations, but the hotbed issue, and this is the second point, would be what is happening at the states. Because now I think the states have not been in a position, to your point, Eduardo, that they are just letting this issue play out and hoping for the best outcome as kind of business works its way to develop out the different AI based technologies. And so for the past several years, we've seen, big privacy oriented comprehensive laws come into place, similar to, the closest thing that we have in the United States to the GDPR, but that I think in 2025 has been certainly areas, a lot of concern, a lot of updating those laws and developments of new different types of comprehensive frameworks. But I think the focus really has been on specific aspects of both privacy and call it privacy adjacent issues. Things around AI profiling or AI enabled chatbots, areas where we have algorithmic transparency, universal opt-out signals, areas around age gating and price discrimination, things that are very much focused on data, but not necessarily focused on privacy aspects of data. And that has been where a lot of the debate has happened in 2025. And my guess is that will continue into 2026. Probably two other things I would flag in the way that where I think about key themes in 2020 and 2025. One has been around national geopolitics and the change in viewing personal data as an area of potential national security concerns. That has been a new development here in 2025, has not been enforced in a way that, has created a lot of specific prominent cases, but has really resulted in a lot of concern and scrutiny for companies as they evaluate their supply chain and they evaluate their data mapping and they evaluate how is it that data is moving all around the world. And then I think the last thing is maybe a hybrid between cybersecurity and litigation. I would imagine 2025 has had so many cybersecurity issues that are cutting across so many different sectors. And what we have found is that the threat actors' tactics have evolved. They've gotten much more sophisticated. They've become much more tailored. And many of the defenses that organizations have used in the past are just no longer working. And the threat actors have specifically identified effectively the weakest link in companies' cybersecurity posture and really targeted those. That has been through the form of social engineering, areas where they've been looking at things where you're targeting help desks, whose people are responsible for being helpful, and then weaponized that helpfulness to be able to result in a cybersecurity issue, which is then translated into just litigation after litigation after litigation. It's almost that every single prominent data breach is going to be followed by class action lawsuit after class action lawsuit. And you have found that the plaintiffs' lawyers here are just waiting for the next one to be announced for them to file the litigation. And it's not only cyber, they've also done the same thing in some aspects of privacy. My guess is that they will continue to focus on that. But it's really been this kind of cyber and litigation kind of dynamic, which has been a big theme over the course of the past year.
Wow. A number of very interesting topics indeed. And the question is, how many of these, or which ones of these, do we think will carry on being top topics and areas of focus in 2026?
I think that's right. I mean, I would say the first question I have for you on that one, Eduardo, because to me, we've spent a lot of time over 2024, 2025 talking about AI governance. And in some ways, like I have found that clients are just like, I don't want to hear any more about AI governance. It's just like, governance, governance, governance. But as I kind of try to take my big view picture of what the EU AI Act looks like, and in the way to try to approach compliance with other AI oriented laws, is that AI governance will become almost real law. Like that will actually be a law to have the AI governance program. So maybe from your perspective, given that AI regulation is being led out of the UK and the EU, interested in your perspective on AI governance and how you see that being a trend in continuing into 2026.
So it is going to be, I think, one of the top issues of 2026, AI governance. But I think we need to understand well what we mean by that. When you look at the laws around AI, and I'm talking about AI-specific laws, you basically have three approaches around the world. You have the new prescriptive laws that are targeting AI very specifically, the AI Act being a wonderful example, but also the state laws that you have in the US. But we've also seen AI-specific laws in places like China and India with very specific labeling requirements and so on. So that's one element. You also have some laws that are literally pro-innovation laws. So they don't impose requirements, they just make sure that the framework and the opportunities are there in order for AI to take off. And we've seen examples of those laws, for example, in Japan, in Korea to an extent, and the UK is probably going to try to go down that route in 2026. And then, of course, you've got other countries that are saying, well, look, whilst we think what we're doing, we're just going to remind everybody that existing laws applies. And then, of course, you go back to privacy or employment issues or cybersecurity requirements and all that. And therefore, AI governance becomes this exercise of trying to manage all of these, the new specific laws, the ones that are pro-innovation, and then the existing laws. And because these are also changing all the time, and of course, the EU AI Act, we thought just a few weeks ago, we thought that we knew what was coming into effect when. Today, we don't. If you look at the AI Act and the way in which it is being implemented, is quite messy. Because, of course, some aspects of the law came into effect at the beginning of this year. And we know in the EU that certain practices are regarded as prohibited and cannot take place because they are unlawful. Then in the summer, we saw the general purpose AI model provisions come into effect, and then the big AI developers, the big AI players are grappling with that. But of course, the main body of the act, of the AI Act, which is meant to come into effect next summer in August 2026, is the one that is now a little bit up in the air because the European Commission is saying, oh, well, maybe we should wait a year or two before this comes into effect. So here we are at the end of 2025 with potentially a law that could become a global point of reference, with the main provisions technically coming into effect in 8 months, in August 2026, but that may not come into effect in the end. So I think that is the challenge of AI governance, that we don't even know which laws are coming into effect when. And I think the way to approach that, and the work that all of our team has been doing over the past, frankly, few years, and I think we're going to continue to do in 2026, is to say, okay, let's take all of this into account. Let's come up with some principles that we can deploy globally, and then pay attention to what's happening, obviously, in the EU, but also in the US at the state level, and in China, and in other places, and almost move as you or make decisions as things evolve. And that's what AI governance is going to look like in 2026, I feel.
No, I think that's really good and important. I mean, I think that way of creating resiliency and sustainability is at bottom trying to come up with an effective AI governance, just given how volatile the policy is in this space and all of those competing interests that you started the episode by talking about. Um, Interested in your perspective about the other areas of regulatory priority in the EU and the UK outside of AI. You mentioned children's data as being a top issue. That's certainly been the case in the United States.
Children are seen as, I guess, the common denominator in terms of what worries regulators and what everybody, whether we're talking of policymakers or the public at large, care about and worry about. And therefore, it is not surprising that data protection authorities, again, both in the UK and the EU, have focused on dealing with children data issues. Literally, last week, the ICO announced a set of investigations around mobile games and how mobile games are targeted at children. So when children are part of the equation, I think all regulators agree that that privacy needs to be prioritized, that compliance needs to be a top concern. And the interesting thing there is that if the response is to say, okay, well, let's avoid dealing with children, like many businesses are trying to do, then the idea of age verification, or the concept of age verification, becomes very real. And then that overlaps with another sensitive topic, which is biometrics, because, of course, a very easy and reliable form of age verification is to undertake some kind of biometric control, whether it's a selfie or some other form of identification that will verify whether someone is an adult or not. And therefore, you can see how, in order to address one topic, you step into another sensitive issue. And that is I think, the point of reference that we need to be aware of, that to the extent that, aside from AI, things like biometrics or things like children data are overlapping, that is going to be a top priority for regulators, certainly in Europe, but I would say everywhere.
And Eduardo, you're making some fantastic points. We could probably spend a lot of time talking about the ways that the interactions of these regulatory requirements and the competing priorities, but thinking about the data minimization principle under GDPR, what does that mean for collecting additional information for age verification or sensitive data and biometrics? All of these things are coming together, but maybe at bottom, one of the things that it seems to me as unique about this is that in the United States, as you know, we've long had this issue where we treat different types of data with respect to different types of data subjects differently from a regulatory perspective. Kind of the least amount of regulation, perhaps in the employment space, with the most amount of regulation going in the direction of children. And one of the appeals about the GDPR and the ways that the Europeans have approached this has been, they don't separate that and so in the same way. And if you're now in the position where children issues are becoming a top priority, it seems like you're moving more in the direction of how the United States has approached this issue with coming up with different segments of data subjects and then treating their data as different. Anything to that?
So, well, interesting then that we are perhaps seeing a degree of alignment between Europe and the US, which anyone today would say, how can that be possible in any shape or form? But seriously, I think there is a degree of truth in the fact that whilst, in a sense, all personal data is, in a sense, regulated in the same way, putting aside the special category data, when you are dealing with more vulnerable individuals, because of the risk-based approach of the law, and we mustn't forget that, and that risk-based approach will continue whether there are reforms to the law or not. And that risk-based approach is looked at by both organizations that are trying to comply with the law and decide whether they need to do data protection impact assessments or notify regulators of a data breach or take any specific steps based on that risk. But also from the point of view of regulators trying to prioritize their actions and their supervision duties. And again, in a world where we have seen technology taking this sort of pervasive role in our lives, it's almost like a desperate, urgent measure that regulators are adopting and saying, let's protect the most vulnerable as a starting point, and we'll figure out how we get to the rest. And I think that thinking is very much alive in Europe today.
Well, if you follow our path, you're soon going to start to transition off children's and start talking about health data, biometric data relating to some sort of special conditions and special groups, have financial data, right? So there's a track record when we can show it to you about how is it that we have moved from one sensitive group to another.
Excellent. I'm looking forward to that. But also, I would say that it seems bizarre in a way that here we are talking about a law that, as I was saying earlier, has been evolving from the 90s or since the 90s. And the concept of personal data in itself is evolving. And of course, this is one of the things that the reform of the GDPR is looking into, and to what extent personal data in my hands may still be personal data in your hands if you're not able to identify, or you are unlikely to be able to identify who the individuals behind that data are. And again, that shows the evolution of the law in the same way that the technology itself is evolving.
Yeah, 100%. All right. Well, to round out UK and EU, any other predictions for 2026, Eduardo?
Well, I think you cannot have me on a podcast and me not mention international data transfers. I think that that is something that sometimes we forget about, or in recent times we have forgotten about, perhaps because we've spoken so much about it in the past that we are taking a break. But 2026, I think, is going to be an absolute essential year for the way in which international data transfers are regulated. And interested in your perspective from your side of the Atlantic. But certainly, at this end, what we have is a number of potential developments in the pipeline, because in the same way over the years we have seen the Schrems cases. In 2026, we will probably see the Latombe case. So the Latombe case is essentially a challenge of the data privacy framework by an individual whose name is Latombe and is a French politician, and is trying to argue that whatever the US did in order to patch the weaknesses of the privacy shield has not been resolved with the data privacy framework. So that is there in the pipeline. But there are other, perhaps more mundane, but still very relevant developments taking place in Europe, because the European Commission is working on a new set of standard contractual clauses for transfers of data to recipients who may be subject to the GDPR, even if they are outside the EU. And also the EDPB is working on a new set of requirements for processor binding corporate rules. And again, binding corporate rules, people forget about them in many cases, but the EDPB has been extremely prolific this year in 2025, approving a set of new sets of binding corporate rules. So for the processor ones, a new list of requirements will be published very likely at the very beginning of 2026. And for those big service providers that are looking at operating globally, but in this very messy, geopolitically charged world, will have to see how they can meet the requirements, or whether they can meet the requirements of the new version of the processor BCR in order to suit the expectations, or to meet the expectations of European regulators. So loads of interesting changes in the pipeline.
Yeah, it's fascinating that you were describing that, because, I think international data transfers on this side of the Atlantic has now found its moment. We have never really spent a lot of time focused on international data transfers, and instead have very much prioritized the value of allowing data to transfer around globally. That has changed in 2025. It's changed really in maybe three different ways. So we've seen some states start to pop up with their own data localization laws, in particular surrounding EHR data, or data health information that would reside inside of electronic medical records. That's new. We have the DOJ rules, which I mentioned earlier, which are very much focused on transfers of data to countries with adversary relationships with the United States. And at the top of that list for most of our listeners is going to be China. And that has been a giant issue. And then interestingly, you may have seen that the chairman of the FTC kind of talking about transfers of data to the EU, and concerns around how US companies can be able to maintain some commitments around your free speech and kind of other aspects of the things that we do, while trying to also maintain compliance with EU law, which is kind of a fascinating reversal of some of the issues that we have long been trying to address. So I agree with your prediction. 2026 will continue with a very much of a focus on data localization, data and how that relates to the geopolitics and national security, and very much of a focus of thinking about data to address non-privacy related concerns as you're thinking about localization. So 100% aligned there. I think some of the things that you described for what's you're expecting in 2026 for the EU and UK, same deal, I think, for the US. Children's data has long been an issue. It's been the most popular area where there's bipartisan support to be able to address impacts of technology and data related issues on children. That will certainly continue. That will create lots of concerns for website operators to try to understand how is it that they are doing different types of age gating and how they're trying to implement this, because many times It's going to be left to the operators, to the platforms, to the app stores, all of them to figure it out about how is it that they're trying to address this population. And we'll put real difficulty on them to try to come up and operationalize what are easy policy issues to articulate, but very difficult things to actually implement. So that will continue. But I think we'll probably also start to see aspects of the way that AI is being used by business that may create larger concerns, not only from a privacy perspective, but maybe even more so from just a straight consumer protection perspective. In the EU and UK, you have a more clear separation between data privacy and consumer protection than we do here in the United States, because consumer protection and privacy are often kind of linked together. But issues surrounding AI enabled price variability, being able to target individuals using personal data to give them specific pricing that is unique to them. You find somebody who, is their information reveals that they have a lot of money, perhaps you charge them more than it is that you charge somebody who, according to your other data, doesn't have as much. So that issue, I think, will be ones where businesses are going to naturally see that there are opportunities there. And I think there's going to be very real uh, difficulty with the regulators about how they're going to approach those issues, and then, frankly, how consumers are going to think about how they're going to manage that. Because you can imagine there are going to be very different points of view about how to handle that issue, and that's going to come at a moment where there is a lot of consternation and debate around affordability in the United States. That's been the key trend or key issue that we've been talking about really for the past year with different types of inflation numbers. But, that issue is probably the technology component of that is going to come in, especially as you have that algorithmic, pricing and potentially transparency applications. Then the last thing I would say is that I think you're also going to see on the AI front that there's going to be a change perhaps around how we're thinking about AI, not only from your own product development perspective, but see how agentic AI is going to start to shape up. And that's going to have so many different applications and so many different issues. But I think one of the things you're going to start to understand and try to start to get out in front of is going to be how that implicates the supply chain, and how two different agentic AIs are going to be connected to one another, and to what level does any organization have a responsibility to really understand how all of these different AI systems are working together or not working together, that may result in any number of different harms. And those can be IP harms, those can be privacy harms, those can be issues surrounding product liability. There's just the universe of potential harms here is hard to even define. But I think that is going to be a challenge in 2026 as to how is it that organizations can be able to manage that. It's almost the parallel in 2025. We've seen a lot of focus on tracking technologies online, basic cookie stuff that the Europeans have been focused on for a very long time, in the United States really has not been. And to start to peel back the layers of the ad tech ecosystem and how all of those entities interconnect and interrelate, and who is responsible for what, and who is doing what, and who's satisfying this obligation, who's satisfying that obligation, has been a real big challenge. And I think that same theme is going to cut across what we see in AI developments for this over the course of this next year. And then the last thing I would say is I don't think the litigation is going away. Litigation is here to stay, sadly, until we start seeing much more comprehensive reform. And I think you have seen the number of plaintiffs' lawyers and plaintiffs' firms who have targeted privacy and different aspects of privacy. That group is here to stay. I think they will target cyber. I think they will target kind of the use and collection of information online. They will start to focus on aspects of mobile applications in ways that they haven't been able to before. And I think they will start moving into AI, frankly, because that now they start seeing like, hey, nobody has a full appreciation of how all of this works. And that was the issue with tracking technology, and that's why so many lawsuits were filed. I think AI has a lot of those same types of themes that are also going to be attractive to the plaintiffs' firms who are looking to weaponize that lack of understanding.
Well, so look, all I have to add to that is, well, first of all, in relation to cookies and cookie consent, to those who are hoping that the days of cookie banners and cookie consent buttons are over, I'm afraid to tell you they're not over. And even if the changes to the e-privacy directive that, again, the European Commission is trying to bring forward go ahead, they will not affect the use of cookies in the context of ad tech and social media and, again, tracking technology. So the consent requirement is here to stay in the vast majority of cases. The final word I would say about AI, agreeing with everything you've said and almost summarizing it, is that AI is essentially a tool for decision making. And that's what it's going to be in the future, in the sense that we as individuals are delegating decisions to AI. Some very trivial, but some very important. And the more important the decisions are, the greater the impact on people's lives. And that's what the law is trying to regulate across the board. And as you say, it engages privacy-related issues, and certainly there are specific articles in the European Data Protection Framework and the GDPR dealing with automated decision-making, so that will be very relevant in this context. But of course, consumer protection, employment, and product liability, and other aspects of the law that are engaged in that AI-based decision-making. And the very final thing I would like to say, and I think is almost trying to end on a positive and optimistic note, is that I think those who work in this area, like you and me and all of our clients, but also activists and regulators, we really need to think a bit about the fact that we are ultimately all on the same side. We're trying to get these things right. And I think 2026, I think, is also an opportunity for collaboration, for regulators to understand about the law and about the technology, for companies to understand about why laws exist and why they are going in the direction they are going. And I think it is partly our job to make sure that we play a role in making this work and going in that direction. So I can imagine that our interaction with our audience, like this wonderful audience that we have for this podcast, but our clients and everyone that we interact with in this world will be more relevant than ever. So AI or not AI, I think hopefully we're here to stay as well.
Yeah, I think it certainly takes a village to solve these issues. So, Eduardo, I appreciate your collaboration in 2025, and I'm excited to see what we can accomplish together in 2026.
Really looking forward to that. Thank you, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.